Your home is not your castle if the warrant has the wrong address. There is a legal principle, 400 years old and embedded in Anglo-American law since Sir Edward Coke wrote it down in 1604, that a person's home is their castle. The idea is that the home is a domain of privacy and safety that the law should protect against arbitrary intrusion. It is, in the American constitutional tradition, the specific right addressed by the Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effect against unreasonable searches and seizures. It is why a search warrant must be issued by a judge, must be based on probable cause, and must describe with specificity the place to be searched and the things to be seized. The castle doctrine is not an abstraction. It is a lived daily experience of tens of millions of Americans who go to sleep at night believing that the door between them and the world outside is a meaningful line, that nothing authorized by law will come through it unless someone, somewhere, has done the work to verify that they are the right person, the right address. Today's 4 cases are about what happens when that work is not done. The 4 situations in today's episode are distinct in their causes and their consequences, but they are all variations of the same foundational error. Law enforcement came through a door that was not theirs to come through. In some of today's cases, the error was an intelligence failure, bad information provided by a paid informant, or an improperly vetted tip, leading officers to a location that had nothing to do with the crime they were investigating. In one case, the error was technological. A detective who did not understand the inherent limitations of consumer smartphone app that was never designed for law enforcement use and who presented its imprecise data to a judge as if it were precise, obtaining a warrant that should never have been signed. In one case, the error was navigational. A federal SWAT team led by an agent whose personal GPS device directed him to the wrong street, who then ignored visible street signs and a house number on a mailbox that would have corrected the mistake before the door was breached and the flashbang grenade was thrown and the 7-year-old boy crawled under his bed. And in one case, the error was tactical, a SWAT team confused by an active shooter situation who spent 3 hours raiding the house of an innocent couple whose only involvement in that evening was that an officer had taken shelter in their garage while being shot at by a neighbor across the street. These are not edge cases in the statistical sense. The American Civil Liberties Union has documented hundreds of wrong house raids across the United States. The CBS News Chicago investigative team spent years cataloging a pattern of wrong house raids by the Chicago Police Department, finding more than a dozen documented cases since 2015 in which innocent families were terrorized by officers with search warrants for their neighbors. The Institute for Justice, the non-profit legal organization that has litigated several of today's cases, tracks wrong house raids nationally as part of its property rights and government accountability practice. Researchers at Wake Forest University Law School have studied the phenomenon and found that the existing legal framework, dominated by qualified immunity for officers and sovereign immunity for government, makes it extremely difficult for innocent victims of wrong house raids to obtain any compensation at all, regardless of how clearly the mistake was the department's fault. Today's 4 cases span 8 years, from 2017 to 2025. They involve a social worker in Chicago, a grandmother in Denver, a family in suburban Atlanta, and a couple in Austin, Texas. Their cases have between them produced a Supreme Court ruling, a multi-million-dollar jury verdict, a city settlement of nearly $3 million, and a situation in which a city government spent more than 6 times the amount of money it owed an innocent couple in legal fees rather than simply pay what it owed. Every detail in today's episode comes from court records, official law enforcement releases, Department of Justice materials, Supreme Court filings, investigative journalism, and the verified accounts of the families involved. What the 4 cases together produce is not simply a story about law enforcement error. They produce a story about what happens to innocent people after law enforcement error, the legal war they face when they try to get any acknowledgement that what happened to them was wrong, and what a few of them have managed to do about it anyway. Before the first case, I want you to pay attention to a specific question that runs through all 4 situations today. At each point in each case where a human being made a decision, the officer who drafted the warrant, the supervisor who signed off on it, the agent who chose the address, the SWAT team that breached the door, the city lawyer who denied the claim. What would have had to be different for the outcome to be different? Not what laws or systems need to change. What specific human decision, at what specific moment, was the one that could have changed this? Track that moment in each case and tell me what you find in the comments. You've got the wrong house. Chicago, Illinois, February 21st, 2019, $2.9 million settlement. December 2021. Thursday evening, February 21st, 2019. Anjanette Young, a 38-year-old Chicago social worker, is in her near West Side apartment at 1139 South Karlov Avenue. She has worked all day in a profession that requires her to enter the lives of people in crisis and try to help them. She is in her bedroom. She is undressing and changing her clothes in preparation for an evening of relaxation. A quiet night at home, she has said, with an episode of Grey's Anatomy. The door to her apartment bursts open. In the next seconds, a swarm of officers, there will eventually be more than a dozen of them, all male, pour into her home with weapons drawn. They are executing a search warrant. They are looking for a man they believe lives at this address and is in possession of a firearm. Anjanette Young is handcuffed. She is standing in her own bedroom with no clothes on, surrounded by armed male officers, telling them as clearly as any person has ever told anyone anything. You have the wrong house. You've got the wrong house. They do not leave. Over the next 40 minutes, officers remain in Anjanette Young's home, searching it with weapons raised, while she stands handcuffed and unclothed. It takes approximately 10 minutes before an officer places a jacket over her shoulders. A blanket follows shortly after. She is eventually allowed to dress, after which she is handcuffed again. The total duration of her time in handcuffs during the raid is 17 minutes. She is asking them to leave from the moment they enter. She asks repeatedly. She tells them again and again, this is the wrong house. She says it while handcuffed and naked in a room full of strangers with guns. She says it while they are searching her home. She says it the whole time. They stay the entire 40 minutes. The man they were looking for. The man the officers were looking for, the subject of the search warrant that authorized the raid on Anjanette Young's apartment, lived next door. He lived in the adjacent unit in the same building. He was, at the time of the raid, wearing an electronic monitoring device that law enforcement could have tracked to a specific unit if they had done so. The search warrant was obtained by Officer Alan Aparonga, who was responsible for verifying the address before applying for the warrant. The Civilian Office of Police Accountability investigation that followed found that Aparonga had obtained the warrant based on information that a paid informant had provided, information that was, in the words of the subsequent legal analysis, fictitious. A paid informant had provided false information in exchange for payment. The address the informant provided was wrong. The warrant was issued for the wrong unit in the building. The man with the gun was in the next apartment. He was wearing a device that, had anyone checked, would have directed officers to his door rather than Anjanette Young's. None of that checking happened. The specific failure that the Civilian Office of Police Accountability documented in its 18-month investigation, a probe involving more than 30 interviews, hundreds of pages of evidence, and hours of video material, was not a single spontaneous error but a cascade of missteps. The informant's information was not independently corroborated before being used in the warrant application. The address was not verified against the electronic monitoring records that would have shown the target's actual location, and the warrant, once obtained, was executed with a tactical aggression disproportionate to the available information. 12 male officers with drawn weapons for a search based entirely on the word of a paid informant who had been paid to tell them something. The video that changed everything. Anjanette Young filed for the body cam footage from the raid through a Freedom of Information Act request. The city of Chicago initially denied the request. She persisted. The footage was eventually provided to her attorney, Keenan Salter, subject to a protective order from a federal judge prohibiting its release to the public. On December 14, 2020, more than a year and a half after the raid, CBS News Chicago aired the body camera footage, having obtained it from Salter in violation of the protective order. In the hours before the broadcast, attorneys for the city of Chicago filed an emergency court motion to prevent CBS from airing the video. CBS aired it anyway. Salter acknowledged the violation of the court order. Young, who had waived a protective order on her own behalf, said she wanted the public to see what happened to her. The footage produced an immediate and sustained national reaction. The images of Anjanette Young, a professional, educated, employed woman, a social worker who spent her career helping others, standing handcuffed and unclothed in her own home, surrounded by officers who stayed in her apartment for 40 minutes after being told they were in the wrong place, were described by Chicago Police Superintendent David Brown as a violation of her human rights. Mayor Lori Lightfoot apologized. Then it emerged that the mayor's office had been notified of the raid in November 2019, 9 months before the video aired, long before the public knew anything about it, and had done nothing. The mayor's law department, which Young's attorney described as trying to keep this buried, had attempted to stop the broadcast in federal court. Lightfoot forced the resignation of her corporation counsel, a longtime friend who had served with her in the U.S. Attorney's Office, after it emerged that he had authorized the effort to suppress the video. What the investigation found. The Civilian Office of Police Accountability completed its probe in April 2021. It identified nearly 100 separate allegations of misconduct by the officers involved in the Young raid. The most significant findings were directed at 3 officers. Aparonga, who obtained the warrant, received a recommendation of a minimum 180-day suspension, up to and including termination. The 2 supervisory sergeants, Alex Walensky and Corey Petracco, were each recommended for a minimum 1-year suspension, up to termination. Superintendent Brown moved to terminate Walensky. The others faced a disciplinary process, which in Chicago's police department involves the right of appeal and a review process that has historically produced outcomes considerably less severe than the original recommendation. Whether discipline was ultimately imposed at the levels Coper recommended was not fully resolved in the available public record at the time of research. Young filed a federal lawsuit against the city and multiple officers, which was initially dismissed. She filed a second lawsuit in Cook County Circuit Court, naming 12 officers as defendants and alleging conspiracy and cover-up in the handling of the case after the raid. The case went through multiple stages of litigation, settlement negotiations, and prolonged delays before the Chicago City Council Finance Committee considered a proposed settlement in late 2021. On December 15, 2021, the full City Council voted unanimously to approve a settlement of approximately $2.9 million. Young was in the chamber for the vote. Before the council approved the settlement, Alderman Maria Haddon said to Young directly, "I want to commend you for your courage and for working so hard to ensure that others would not have to experience what you went through." 6 years later, Anjanette Young accepted the settlement. She said publicly that no amount of money could provide her with what she truly wanted, which was to never have been placed in this situation in the first place. She said, "Because financial compensation is the only way civil suits can be resolved, accepting it does not mean I am whole or that justice has been served." As of February 2025, 6 years after the raid, Young was still fighting. Not for money. For a specific piece of legislation she has spent 6 years trying to get the Chicago City Council to pass, the Anjanette Young Ordinance. The proposed ordinance would require Chicago police officers to give people at least 30 seconds to answer their door before breaching it during the service of a search warrant. 30 seconds. It would also contain language explicitly prohibiting officers from pointing firearms at children during raids. Alderman Maria Haddon, who has led the push for the ordinance since 2021, made the stakes plain at a February 2025 event marking the 6th anniversary of the raid. Give people 30 seconds. We are just asking for 30 seconds. We think it is unconscionable to have to fight to ask somebody to not point guns at children. The ordinance had not been passed as of the time this episode was recorded. The city's CBS News investigative team, which had spent years documenting Chicago's pattern of wrong house raids, had identified more than a dozen families who had sued the city since 2015 for raids on the wrong homes. In 2019 alone, the year Anjanette Young's door was broken down, at least 5 separate families filed wrong raid lawsuits against the city of Chicago. The man whose informant gave the wrong address was in the apartment next door. He was wearing an ankle monitor. The information about where he actually was existed in a database that officers could have accessed. Young said at her 6th anniversary event, "The fight is bigger than me. It has always been about protecting every Chicagoan from the fear and powerlessness and trauma that I have endured. Our families and our children cannot afford for another year to feel safe in their homes." Anjanette Young told officers they had the wrong house from the moment they entered. She said it while handcuffed and unclothed. She said it the entire 40 minutes they were there. The man they were looking for lived next door and wore an ankle monitoring device. The informant who provided the address was paid for providing information and provided false information to get paid. It took 6 years and a legal battle that included a city government attempting to suppress body cam footage in federal court before she received a settlement of $2.9 million. And she still says it is not justice. The ordinance she has been fighting for since then, 30 seconds before breaking down a door, no guns at children, had not been passed as of the time this episode was recorded. What does it say about a city's institutional priorities when passing a law that says wait 30 seconds before breaking someone's door down requires 6 years of fighting? Tell me in the comments. February 21st, 2019, near West Side Chicago, and Jeanette Young changing her clothes. Her door burst open. 12 male officers with drawn weapons, handcuffed and unclothed for 10 minutes before a jacket. 17 minutes in handcuffs total. You have the wrong house. You have the wrong house. Set every minute for 40 minutes. The man they wanted lived next door. He wore an ankle monitor. The informant was paid for false information. The city tried to suppress the body cam footage in federal court. CBS aired it anyway. A unanimous city council vote. $2.9 million. Young said it is not justice. 6 years later, still fighting for 30 seconds, the time she was never given before her door was broken down. The ordinance had not been passed. The fight is bigger than her. She has been saying so for 6 years. The app said so. Denver, Colorado, January 4th, 2022 $4 million jury verdict. March 2024. Wednesday morning, January 4th, 2022. The Montbello neighborhood of Denver, Colorado, a working-class community on the northeastern edge of the city, where Ruby Johnson, 73 years old at the time, has lived in a single-family home for 43 years. She raised 3 children in that house as a single mother, going without Christmas presents and birthday gifts in lean years so she could afford the mortgage and keep the lights on. She is a retired United States Postal Service worker. She is a grandmother. She is, on this Wednesday morning, inside her home when she hears a loudspeaker blaring from outside. She goes to the window. In her front yard is an armored military personnel carrier. On her street are multiple Denver Police Department vehicles. Surrounding her property are numerous officers in full tactical gear carrying rifles. There's a K-9 German Shepherd with them. Ruby Johnson goes to her front door, wearing her bathrobe, her bonnet, and her slippers, and she opens it. Officers order her out of her home at gunpoint. She is placed in a police cruiser. She is detained in the back of that cruiser for several hours while officers enter her home and search it, ransacking it in ways she will only see when they let her back inside. No one explains to her what is happening. No one tells her why she is in the cruiser. She is simply there, in her bathrobe, while her home of 43 years is turned upside down. The day before, January 3rd, 2022, a truck had been stolen from a Denver hotel parking garage. The truck's owner, Jeremy McDaniel, told Denver police that his vehicle contained 4 semi-automatic handguns, a tactical military-style rifle, a revolver, 2 drones, $4,000 in cash, and an old iPhone 11. McDaniel told the detective assigned to the case, Gary Staub, that he had been using Apple's Find My app to try to locate his stolen belongings. Find My is a consumer smartphone application. Apple's own documentation is explicit about its limitations. It uses information from cellular networks, Wi-Fi networks, GPS, and Bluetooth to determine the approximate location of a device. It is not intended as a law enforcement tool. Numerous factors affect the accuracy of its location data, including the number of visible GPS satellites, weather conditions, building materials, terrain, and the presence of other wireless signals. At its most precise, it typically indicates a radius of several city blocks. At its least precise, it indicates a general neighborhood, the warrant that should not have been signed. Detective Staub took the data from the Find My app and used it to apply for a search warrant for Ruby Johnson's home. The application, a sworn affidavit presented to a judge, stated that the stolen iPhone had pinged to the address of Johnson's home on 2 separate occasions. The affidavit included a screenshot from the app. The screenshot showed a circle indicating the possible location of the phone. That circle, as the subsequent lawsuit established, encompassed at least 6 different properties and parts of 4 different city blocks in the vicinity of Johnson's home. It did not specifically or precisely identify her address above any of the other properties within that circle. Staub's affidavit did not disclose this. It did not inform the reviewing judge of the known limitations of the Find My app. It did not note that the app explicitly states its location data is approximate. It did not indicate that Staub had done any independent investigation to confirm whether the phone was in Johnson's home versus any of the other properties within the circle. The affidavit contained what the ACLU of Colorado, which later represented Johnson in her lawsuit, described as representations by the officers to the judge that the app's data were precise when it was not. A judge signed the warrant. No independent corroboration of Johnson's connection to the stolen truck was required. No verification that she had any connection to McDaniel or to the theft was conducted. No evidence linking her specifically to the phone's location rather than any other property within the several block radius of the app circle was gathered or presented. There was, in addition to the app screenshot, one other detail. The affidavit contained dates type as occurring in 2021, when the theft had actually occurred in 2022. The ACLU argued at trial that the typo indicated the absence of care with which the affidavit was drafted, reviewed, and approved. The affidavit was reviewed by Sergeant Gregory Bushy before submission. It was approved. It was signed by the judge. On January 4, 2022, the SWAT team drove to Ruby Johnson's house. What they did inside. Ruby Johnson told the officers how to open her garage door. They used a battering ram on it anyway. They broke ceiling tiles to access her attic. They went through her belongings. Officers were in her home long enough and thoroughly enough that the damage was significant and visible when she was allowed to return. She was not given an apology. She was not given an explanation. No stolen truck was found. No stolen guns were found. No stolen property of any kind was found. The iPhone that had allegedly pinged to her address was not in her home. When the officers finally acknowledged she had nothing to do with the theft, they left. Johnson suffered what her attorneys described as severe physical and emotional distress in the aftermath of the raid. She developed ulcers. She had difficulty sleeping. The home where she had raised 3 children as a single mother, the home she had saved and sacrificed for, no longer felt safe to her. She eventually moved out of the Mournbelow neighborhood entirely. Her attorney said the biggest damage done to her was the destruction of a sense of safety in a place she had called home for 4 decades. ACLU of Colorado legal director Tim McDonald said, "For us, the damage was always about the psychological and the emotional harm to Ms. Johnson. She was a retired postal worker who had lived in that house for 43 years and who had gone to her front door in her bathrobe because a loudspeaker was in her front yard, and who had opened it to an armored vehicle and a German Shepherd and rifles pointed at her home. The trial and what it produced. The ACLU of Colorado filed a lawsuit on Johnson's behalf against Detective Staub and Sergeant Bushy as individuals. The lawsuit was brought under provision of a sweeping Colorado police reform law passed in 2020 following the death of George Floyd, a law that, for the first time, allowed people to sue individual police officers in state court for violations of the Colorado Constitution's protections against unreasonable search and seizure. Previously, claims of this kind could only be brought in federal court, where qualified immunity had made it effectively impossible for most plaintiffs to prevail. The new Colorado law removed that barrier at the state level. The case went to trial in Denver District Court in early 2024. Jurors heard testimony about the limitations of the Find My app, about Staub's failure to disclose those limitations in the warrant affidavit, about the lack of independent corroboration, and about the experience of Ruby Johnson on January 4, 2022. They saw the body cam footage of the raid, released by the Denver Police Department. They saw Johnson standing in front of her home in her bathrobe while officers surrounded it. The jury deliberated and returned a verdict on March 1, 2024, finding both Staub and Bushy liable for violating Johnson's constitutional right to be free from an unreasonable search and seizure. The jury found specifically that both officers had acted with willful and wanton disregard for her rights. The verdict was $1.26 million in compensatory damages and $2.5 million in punitive damages, a total of $3.76 million. A Denver district judge subsequently reviewed the verdict and increased the total award, with prejudgment interest, to more than $4 million. The department's response. The Denver Police Department, which was not named as a defendant in the lawsuit, declined to comment on the jury verdict. A department spokesperson told reporters and news outlets that an internal review of the incident had resulted in no formal discipline for the officers and no change in search warrant policies. The spokesperson said the officers were acting based on a search warrant that was approved and signed by the district attorney's office and a judge. That statement, placing the legal responsibility on the judge who signed the warrant rather than on the officer who provided the judge with misleading information about what the app's data actually showed, was the department's final public position on the matter. Rebecca Wallace, the ACLU attorney who tried the case, said after the verdict, the detective misled the court by portraying the phone pings as precise location data. The jury said that misrepresentation and the resulting raid on an innocent grandmother's home was not acceptable and carried a price. For the first time under Colorado's new law, That price was paid by the specific officers whose decisions produced the outcome, not by an immunity doctrine that would have shielded them from any consequence at all. Johnson's attorneys acknowledged that the $4 million would not undo what happened on January 4, 2022. The home she had lived in for 43 years is now someone else's home. The sense of safety she had built in that neighborhood across 4 decades is gone. The ACLU said the case sent a clear message. Police can be held accountable for invading someone's home without probable cause. Johnson was 78 years old when the verdict was announced. The Apple Find My app that started the chain of events that brought a SWAT team to her door was, as it has always been, a consumer product designed to help ordinary people locate misplaced personal devices. It is not a law enforcement database. It is not a GPS tracker with legal precision. Its error rate spans city blocks. The detective who used it to put a battering ram through a grandmother's garage door had no training in its limitations and did not mention those limitations to the judge who signed the warrant. A detective used a consumer app he had no training on to obtain a search warrant, telling the judge the app's location data was precise when the app's own documentation said it was not. The warrant affidavit had typos suggesting it was drafted without care. No independent corroboration was sought. A grandmother who had lived in her home for 43 years was detained in a police cruiser in her bathrobe while her belongings were searched and her property was damaged. The department's internal review found no basis for discipline. A jury said otherwise and awarded $4 million. The department's response was that the officers were following a signed warrant. The law that allowed the jury to hold the individual officers accountable existed because the state of Colorado passed it in 2020. Without that law, Johnson would have faced federal qualified immunity and almost certainly received nothing. What does it say about the state of Fourth Amendment protections in the United States that the legal framework that made her verdict possible did not exist in Colorado 3 years before her door was broken down? Tell me in the comments. 43 years. A single mother who skipped Christmas presents to keep the mortgage paid. A retired postal worker. A bathrobe and a bonnet and a loudspeaker in her front yard. An armored vehicle. A battering ram through a garage door she offered to show them how to open. Several hours in a police cruiser while they went through everything she owned. No truck, no guns, no connection to any crime. An app designed to find lost phones used to issue a SWAT warrant for a home that contained only a grandmother. A jury of 12 people, $4 million. The department, no discipline, no policy change. The officers were following a signed warrant. The law that made her verdict possible was passed 2 years before the raid. Without it, she would have received nothing. She moved out of the neighborhood. The sense of safety in her home of 43 years is not coming back. The GPS said turn here. It was wrong. Suburban Atlanta, Georgia, October 18, 2017. Supreme Court ruling June 12, 2025. Wednesday morning, October 18, 2017. Before dawn. 3756 Denville Trace, a quiet residential street in suburban Atlanta, Georgia. Kautrina Martin is asleep inside with her partner, Hilliard Toyclight, and her 7-year-old son, Gabe. They have been asleep. It is dark and quiet in the way that suburban Atlanta neighborhoods are dark and quiet in the early morning hours of a weekday. Then a battering ram hits the front door. Then a flashbang grenade detonates inside the house. The sound, Clyde will later say, was monstrous. Trina Martin's first instinct, on hearing the explosion, is to run toward her son's bedroom. Clyde, whose first thought is that the house is being broken into by criminals, reaches for the shotgun he keeps nearby. He hesitates only because something about the sounds makes him think this might be law enforcement. That hesitation saves his life. Before he can decide, an FBI agent opens the door and grabs him. He is thrown to the floor. He is handcuffed. He is questioned. He is asked what he has done. He answers the question from the floor. FBI agents in tactical gear move through the house. They find Trina Martin, half-dressed, in a room full of armed strangers. She is held at gunpoint. She cannot reach her son. From another room, she and Clyde can hear Gabe, 7 years old, alone, terrified, crying for his mother. He is hidden under his bed. He is 7 years old, and he is under his bed in the dark while a flashbang grenade has just gone off in his house, and he can hear his mother's voice, but he cannot reach her. The agents tell him to stay where he is. He stays where he is, alone, until it is over. The FBI SWAT team spends approximately 5 minutes in the Martin home. Then one of the agents notices something. He looks at Toy Client. He does not have the tattoos the target of the raid was expected to have. The agent asks Client for his address. Client gives it. 3756 Denville Trace. The room goes silent. The agents were supposed to be at 3741 Landor Lane. They are at the wrong address. The GPS device that was thrown away. The FBI SWAT team assigned to arrest suspected gang member Joseph Riley on October 18, 2017, was led by Special Agent Lawrence Guerra. Riley was believed to be at 3741 Landor Lane. Guerra used his personal GPS device to navigate to the address. His GPS directed him not to Landor Lane but to Denville Trace, a different street, with a different name, with a different house number, in the same general area. The agents approached the house on Denville Trace. The street sign for Denville Trace was visible. The house number 3756 was visible on the mailbox at the end of the driveway. Neither of these things was checked against the warrant. Justice Neil Gorsuch, writing for a unanimous Supreme Court more than 7 years later, noted these facts with a specific precision of someone who wanted to make absolutely clear how avoidable this was. The agents neither noticed the street sign, the sign was visible, nor the house number on the mailbox, which was also visible. If they had noticed either one, the mistake would not have been made. After the raid, Agent Guerra returned to the Martin home to apologize. He gave Martin and Client the business card of his supervisor. Then the FBI left. No one from the FBI contacted them afterward. No one arranged for repairs to their damaged door and property. No one offered counseling or assistance of any kind. No one at the Bureau acknowledged any formal responsibility for what had happened. The SWAT team drove down the street to the correct address, arrested Joseph Riley, who was later convicted, and proceeded with their day. Martin, Client, and young Gabe were left to process what had happened in their home before sunrise on a Wednesday morning. Guerra's personal GPS device, the device whose error caused the team to go to the wrong house, was discarded by Guerra at some point after the raid, before it could be examined or analyzed by investigators. The Institute for Justice, the organization that would eventually take the family's case to the Supreme Court, characterized this fact in its filings and public communications in the plainest possible terms. He threw it away before it could be analyzed. The device that was the mechanism of the error was destroyed by the person who made the error. No explanation was provided for why this was done or when. The GPS device was gone. The legal war. Trina Martin, Toy Client, and Gabe Watson, whose last name is distinct from his mother's, filed a lawsuit against the federal government in 2019, 2 years after the raid. They sued under the Federal Tort Claims Act, a law Congress passed in 1946 that waives some of the federal government's sovereign immunity and allows individuals to sue for injuries caused by federal employees acting within the scope of their duties. The FTCA contains specific language added by Congress in 1974, specifically in response to a series of wrong house raids that produced outrage at the time that creates a cause of action for law enforcement officers who commit assaults, batteries, and related torts against individuals. The family's case was dismissed by the Federal District Court. The U.S. Court of Appeals for the 11th Circuit affirmed the dismissal. The 11th Circuit used a legal doctrine it had developed internally, the Supremacy Clause defense, holding that when federal officers act in furtherance of federal policy and in compliance with federal law, the FTCA's incorporated state tort law cannot impose liability on them, because the Supremacy Clause of the Constitution makes federal law the supreme law of the land. In other words, the 11th Circuit held that because the FBI agents were on a legitimate federal law enforcement mission, the state tort claims the family tried to bring under the FTCA were preempted. The family had nowhere left to go but the Supreme Court. The unanimous Supreme Court decision. On January 27, 2025, the Supreme Court of the United States agreed to hear the case. The case was styled as Martin v. United States, number 24-362. Oral arguments were held on April 29, 2025. The Institute for Justice argued for the Martin family. The federal government argued that the 11th Circuit Supremacy Clause defense should stand, and that the family's claims were barred. On June 12, 2025, 8 years after the agents threw a flashbang grenade into a house where a 7-year-old was sleeping because a GPS device sent them to the wrong street, the Supreme Court issued a unanimous decision. All 9 justices agreed. Justice Neil Gorsuch wrote the majority opinion. The Supremacy Clause, Gorsuch wrote, does not permit the United States to use as a defense against liability under the FTCA in cases like this one. The 11th Circuit's novel supremacy clause theory was wrong. The family's case should proceed. The Supreme Court's ruling was not a final determination that the family would receive compensation. It was a ruling that they had the right to continue fighting for it, that the legal doors of the lower courts had closed should be reopened, and the case should be re-examined. The ruling vacated the 11th Circuit's decision and remanded the case for further proceedings. On remand, the 11th Circuit will be asked to carefully re-examine whether any of the FTCA's other exceptions, including the discretionary function exception that could potentially shield the government from liability for how the agent prepared for and carried out the warrant, apply to bar the family's claims. The Institute for Justice committed to continuing to fight for the family through whatever additional proceedings followed. What the 8 years did. Gabe Watson was 7 years old when FBI agents threw a flashbang grenade into his home before dawn, and he hid under his bed crying for his mother. He was 14 years old when the Supreme Court ruled unanimously that his family had the right to pursue their case. He told a reporter for the Associated Press in 2025 that the experience dramatically altered his life and that he did not really have a childhood growing up because of that. His mother, Katrina Martin, said she had to stop coaching track because a starting pistol reminded her of the flashbang grenade. Toy Clyde said he developed sleeping problems severe enough that he left his job as a truck driver. The business card for Agent Guerra's supervisor, given to the family by Guerra after the raid as a gesture that amounted to "here is someone to call," is presumably still somewhere in the Martin household. Agent Guerra discarded the GPS device. The street sign for Denville Trace was visible. The mailbox at the end of the driveway showed the number 3756. Neither was checked. The correct address was 3741, Landor Lane. The two numbers, 3756 and 3741, are different in every digit past the first. The two street names, Denville Trace and Landor Lane, are different in every letter. The Supreme Court of the United States, writing for itself unanimously, noted that if the agents had noticed a street sign or the house number that was visible on the mailbox, the mistake would have been averted. That is what 8 years of litigation to a 9-0 ruling came to. It would have been averted. The FBI agents threw a flashbang grenade into a family's home before dawn, held a woman at gunpoint, handcuffed her partner on the floor, and left a 7-year-old alone under his bed in the dark, all because a GPS device led them to the wrong street, and they did not verify the address against the street sign or the mailbox number, both of which were visible. The SWAT commander threw away his GPS device before it could be analyzed. The family spent 8 years in court before a unanimous Supreme Court ruled they had the right to keep fighting. The case is still not resolved. What should the standard be for a federal law enforcement agency when the error was as simple, as avoidable, and caused as much harm to 3 people who did nothing wrong? And what should happen to an agent who destroys the evidence of their own error? Tell me in the comments. Before Dawn, October 18th, 2017. Denville Trace versus Landor Lane. 3756 versus 3741. A street sign that was visible. A mailbox number that was visible. Neither checked. A battering ram. A flashbang grenade detonating in a house where a 7-year-old was sleeping. A mother half-dressed at gunpoint unable to reach her son. A man on the floor in handcuffs who had reached for his shotgun and then hesitated because something made him think it might be police. That hesitation saved his life. An agent who noticed the handcuffed man did not have the expected tattoos. Client's address. Silence. The FBI left and went down the street to arrest the person they actually came for. They left the family with a business card for a supervisor. They threw away the GPS device. 8 years later, a unanimous Supreme Court ruling allowing the case to continue. Gabe Watson says he did not really have a childhood. He is 14 years old. The bomb was on our door, not his. Austin, Texas, August 6, 2023. Lawsuit ongoing. City fighting $23,000 claim with $600,000 in legal fees. Sunday evening, August 6, 2023. Channel Island Drive, a residential street in the Parkside at Slaughter Creek neighborhood in southeast Austin, Texas. Glenn and Mindy Shield are in their home. Across the street, their neighbor, a 56-year-old recluse named Dwayne Brzezowski, who had accumulated a stack of code enforcement citations for knee-high grass and about whom the immediate neighbor had recently noticed 4 large wasp nests and not seen for months, is the subject of a welfare check. Two Austin police officers knock on Brzezowski's door. They receive no answer. An officer kicks in the door and announces himself. Brzezowski emerges with a shotgun. He opens fire. One of the officers is shot. The wounded officer runs. He ends up taking cover in the open garage of Glenn and Mindy Shield, across the street. By the time backup arrives, police have set up a perimeter. The suspect, the man who shot the officer, is in his own house across the street. Glenn and Mindy Shield, who live in the garage where the wounded officer sought refuge, are taken into custody. What happens next is 3 hours in which Glenn and Mindy Shield sit handcuffed in the back of police vehicles while watching law enforcement surround their own home, as if their home is the problem, and not the house directly across the street where the man with the shotgun is still inside. A relative of the Shields, named Glenn, is also present and is confronted by an officer who, according to the subsequent lawsuit, places a gun in his face and says, "I am going to kill you." At approximately 11 in the evening, nearly 2 hours after the Shield were taken into custody, doorbell camera footage from their own house shows a SWAT officer placing a strip of explosives along the hinge side of their front door. Mindy Shield later tells reporters the sound of that explosion is what she hears in her sleep. The blast blows the front door off its hinges. It sends with shards across the house. It ruptures the natural gas line. The SWAT team enters and searches the Shield's home. The man who shot the officer was across the street the whole time. At no point during the 3 hours that Glenn and Mindy Shield were handcuffed in police vehicles, at no point while the SWAT team was setting up to breach the door of the house across the street from where Brzezowski lived, the innocent house, the house belonging to people who had been in police custody since before the SWAT team arrived, did law enforcement redirect its tactical attention to the address from which the officer had actually been shot. The man who fired the shotgun was in his own home on Channel Island Drive. He was there from the beginning. He was not in the Shield's home. When the SWAT team finished with the Shield's house, Brzezowski surrendered from his own home in what Austin Police Chief Joe Chacon described to reporters as a short standoff. The Shields were released. There was no explanation given. They had a front door that was a piece of charred wood on its side, a ruptured gas line, an estimated $23,000 in damage, and 3 hours worth of the particular kind of bewilderment and trauma that comes from watching your own home blown open while sitting handcuffed in a police car. The Austin Police Department never told the public that a SWAT unit had blown open the front door of a house across the street from the suspect and searched it. The department's official narrative of the August 6th incident focused on the officer-involved shooting and Brzezowski's surrender, the damage to the Shield's home, the 3 hours of their detention, the explosives used on their door. None of it appeared in the official account. It was the Austin American-Statesman columnist Bridget Grummett who first reported the full story after speaking with the Shields. The Austin Police Department did not answer Grummett's questions, citing an ongoing investigation into the officer-involved shooting. Glenn Shield told Grummett, "I keep thinking about what we could have done differently to prevent this nonsense." Then he nodded toward his neighbor's house and said, "He did not get the bomb. The city that would not pay." The Shields filed a claim with the city of Austin for $23,000 to cover the cost of repairing their home. The city denied the claim. The city's response cited Texas state law providing immunity from liability for property damage to local governments engaged in law enforcement and public safety functions. The Institute for Justice, which had become aware of the case, sent a letter to Austin city officials arguing that the immunity rationale was legally incorrect, that the Texas Constitution, like the U.S. Constitution, requires just compensation when the government takes or damages private property for public use, and that this principle applies to cases where SWAT teams destroy innocent people's property just as it applies to eminent domain. The city did not respond to the letter. The Shields filed a federal lawsuit against the city of Austin, the Austin Police Department, and the Texas Department of Public Safety, asserting claims of assault with a deadly weapon, false arrest, injury to property, and related violations. The city's response to the federal lawsuit was to hire outside attorneys to fight it. Reporting published in March 2026 by the Austin Politics newsletter, which had obtained budget and billing records through public record requests, documented that by that point the city had spent nearly $146,000 in outside attorney fees to fight the Shields' claim. That is more than 6 times the $23,000 the Shields sought for the damage to their home. The city's litigation budget for the case was subsequently raised to $609,500, more than 26 times the original damage claim. The budget increase was approved by the Austin City Council over the objection of community voices who argued the expenditure was both mathematically indefensible and morally wrong. The Austin Politics newsletter editorial board wrote about the case in terms that are worth quoting directly for what they communicate about the logic of the city's position. The city owes Glenn and Mindy Shield an apology. They had also noted that Austin's Mayor Kirk Watson, who voted with a council majority to fund the legal fight with the Shields, attributed the budget growth to the need to respond to countless discovery requests and review over 2,000 documents and hundreds of audio and video recordings. The newsletter's response: well, yes, but that is only because they sued 2 years after the city refused to do the right thing. What Jody Steiger said. Among the details Bridget Grummett reported in her original account of the August 6th incident was a statement from Jody Steiger, a former Los Angeles Police Department officer and nationally recognized authority on police use of force. Grummett asked Steiger about the specific tactical decision to use explosives to breach the Shield's front door, a door that the Shields told officers was unlocked and behind which they also told officers no one was inside. Steiger said it is best practice for SWAT to see if a door is already open before using explosives unless the situation is a hostage standoff or drug warrant search. This was neither. The Shields were in police custody in the back of cruisers. The door was, by their account, unlocked. The suspect was across the street. The SWAT officer placed an explosive strip on the hinge side of the door and set it off, sending shards of wood across the house and rupturing the gas line at 11 in the evening on a Sunday, while the people who owned the house watched from the back of police cars. Glenn Shield told reporters after filing the federal lawsuit, "We will go for the city again. I consider them fully responsible for the whole thing. I feel like it is going to have to take litigation because the city does not seem inclined to do anything." He was right about the litigation being necessary. As of early 2026, more than 2.5 years after the raid, the lawsuit was still being fought, with the city of Austin having spent or authorized the spending of an amount approaching 26 times what it would have cost them to simply fix the Shield's door and say they were sorry on the evening of August 7, 2023. Dwayne Brzezowski, who shot the officer who came to check on his welfare, was the reason any of this happened. His door did not get the bomb. The Shield were people who owned a garage in which an officer happened to take shelter while being shot at. Their door got the bomb. Their gas line got ruptured. Their $23,000 was denied. Their lawsuit is being fought with $600,000 of taxpayer money. The SWAT team spent 3 hours raiding and blowing the door off the home of people who had been in police custody since before the SWAT team arrived, while the actual shooter was in his own home across the street the entire time. The Shields told officers the door was unlocked and no one was inside. Explosives were used on it anyway. The city denied a $23,000 repair claim on immunity grounds. A non-profit organization wrote a letter saying the immunity rationale was incorrect. The city ignored the letter. The Shield sued. The city has spent or authorized spending $600,000 to fight the lawsuit rather than pay the $23,000 it owed. What does it say about how government institutions assess accountability when they choose to spend 26 times the amount they owe rather than acknowledge a mistake? And what should courts do about it when a city responds to a wrong house damage claim by spending years and a small fortune proving they can afford to fight it? Tell me in the comments. August 6, 2023. Channel Island Drive. A welfare check gone wrong. An officer shot by the man who was being checked on. The wounded officer takes cover in the Shield's garage. 3 hours later, SWAT at the Shield's door. A strip of explosives on the hinges. A gas line ruptured. $23,000 in damage. The Shields handcuffed and watching from police cars. Brzezowski, across the street in his own house the whole time, surrendered shortly after the SWAT team finished with the Shields' home. The department's official account never mentioned any of this. The Shields filed a $23,000 claim. The city denied it. The city has since spent or authorized nearly $610,000 in legal fees fighting the claim. Glenn Shield said he considers the city fully responsible for the whole thing. He said he did not get the bomb. He was talking about his neighbor, who had actually shot an officer, whose door, when police finally went back across the street, opened to a surrender after what the police chief called a short standoff. What the castle doctrine actually costs. 4 cases, 4 wrong addresses, for completely different reasons that law enforcement ended up at a door that was not the right door. Fictitious information from a paid informant who was paid to provide it. a consumer smartphone app whose error radii spanned city blocks used as if it were precision law enforcement data to obtain a warrant for grandmother's home. A federal SWAT team that followed a personal GPS device to the wrong street and did not check the visible street sign or the mailbox number before deploying a battering ram. A SWAT unit confused during an active shooter situation who spent 3 hours processing the wrong house while the actual shooter waited across the street. The legal outcomes across these 4 cases are as varied as the causes. Jeanette Young received a $2.9 million settlement after a years-long fight that included a city government attempting to suppress a bodycam footage and a mayor whose administration was politically damaged by the cover-up. Ruby Johnson won a $4 million jury verdict, the first significant trial under Colorado's new police accountability law, from a jury that found 2 specific officers had acted with willful and wanton disregard for her constitutional rights. Trina Martin, toy client, and a boy named Gabe who had under his bed at age 7 received a unanimous Supreme Court ruling at age 14 allowing their case to continue, but no compensation yet, and no promise of it, with the case now heading back to a lower court. Glenn and Mindy Shield have received nothing. The city of Austin has spent or authorized spending roughly $600,000 to fight their $23,000 repair claim, and the fight is ongoing. The legal framework that determines what innocent victims of wrong house raids can receive is one of the most complicated and uneven areas of American civil rights law. At the federal level, qualified immunity protects individual officers from civil liability unless the constitutional violation they committed was clearly established by prior precedent at the time of the violation, a standard that critics argue is nearly impossible to meet because courts regularly refuse to decide whether conduct was a constitutional violation, citing the lack of a prior case with identical facts, while simultaneously declining to create the precedent that would make the next case easier to pursue. At the state level, sovereign immunity protects government from lawsuits in most circumstances unless a specific law waives that immunity, as Colorado's 2020 reform law did, which is a direct reason Ruby Johnson was able to win in court. At the federal level, the FTCA provides a partial waiver of the federal government's immunity, but as the Martin case showed, federal courts had spent years finding exceptions to that waiver in a way that the Supreme Court ultimately found unacceptable. What the 4 cases today produce, collectively, is a picture of a legal system that in some states, under some circumstances, at some levels of government, can be made to work for the people who are wrongly harmed by law enforcement error, but that does not work by default, does not work automatically, and does not work at all without someone willing to spend years fighting. Jeanette Young spent 6 years. The Martin family spent 8 years before reaching the Supreme Court and still has no compensation. Ruby Johnson had the specific advantage of living in Colorado, which had passed a specific law in 2020 that allowed her case to go to trial. The Shields are fighting with a non-profit legal organization behind them. Not every family in every wrong house raid has an ACLU chapter, an Institute for Justice, or an attorney willing to fight a city for years. Most of them have nothing except a broken door and a city that says it is immune. The specific human decisions that produced each of today's 4 outcomes, the officer who did not verify the address against the electronic monitoring records, the detective who presented approximate app data as precise, the SWAT agent who followed a GPS device without checking a street sign or mailbox number, the unit that spent 3 hours on the wrong house, are all individual failures in situations where one different choice, at one different moment, would have changed everything. They are also all products of institutional environments in which the consequences of those individual failures, for the individuals who made them, were minimal. No officer in any of today's 4 cases was criminally charged. In one case, no discipline was imposed at all. In another, the officer who made the navigational error discarded the evidence of the error. The legal consequences for the institutions involved were measured in millions of dollars in settlements and verdicts and legal fees, but the specific people who made the specific decisions mostly moved on. Jeanette Young said 6 years after her door was broken down, "The fight is bigger than me. It has always been about protecting every Chicagoan." She is still fighting for an ordinance that says wait 30 seconds before breaking someone's door down. The ordinance has not been passed. Ruby Johnson moved out of the neighborhood where she raised the children. Gabe Watson told a reporter he did not really have a childhood because of what happened to him at age 7. Glenn and Mindy Shield watched 26 times their repair claim disappear into legal fees while the city of Austin fights them in court. The man who got the bomb on his door says what he keeps coming back to. He did not get the bomb. He was pointing at his neighbor's house, the one where the shooter was. Tell me in the comments which of today's 4 cases you think represents the most complete failure, not the most dramatic wronghouse story, but the one where the system, from the initial error to the aftermath, produced the least accountability and the least proportionate response. New episode coming. See you in the next one.